Yes, thank you everyone for tuning in. And I know that we have folks tuning in from around Canada, around the world. For some of you, it's morning time. For some of us, it's after lunch. For some of us joining from Europe, it's late in the evening. So it's incumbent upon me to make sure I keep us all awake. And I think I will, because this is a story about a very consequential constitutional change, as Dr. Maley said, the reform of Ireland's law on abortion. But for those of us who are interested in constitutional reform and deliberative citizen-centred mechanisms, it's also an exciting story because it's one of those instances in which a citizen-centred innovation, a deliberative mini-public, played a really influential role in a legal change. So, to set a little bit of context here, we are living in times of democratic fragility, to say the least. Even in established democracies around the world, we can see some headline-grabbing events that show just how fragile our democratic processes can be. And even aside from those headline-grabbing events, an equally alarming but perhaps more subtle trend across many established democracies is a decline in trust of individuals and citizens of their elected institutions and their elite institutions. And this is where the rise of deliberative mini-publics has really come into play. It has coincided with the deliberative turn in democratic theory starting in about the 90s. And in the last 10 years or so, we've seen a wave of deliberative, citizen-centered innovations being incorporated into democratic processes. And really, this is an effort to try and involve ordinary citizens more meaningfully in shaping public decisions that affect them. So, what are deliberative mini-publics? Well, there are a variety of different forums and bodies and processes that come under the umbrella term deliberative mini-public, but broadly speaking, what they all have in common is they're usually a representative sample of ordinary citizens. They are chosen by random selection. They deliberate together, they learn about a particular topic, and then they make proposals for change. It could be constitutional change, legislative change, policy change. And the idea is that somehow those citizen recommendations make their way into the broader political process. The OECD reports this wave of these processes worldwide, and it's really Ireland that has taken a leading role internationally in incorporating these deliberative mechanisms into the process of legal change. Deliberative Democrats are particularly interested in Ireland. It's been called the jewel in the crown of deliberative democracy. And one particular example that's often pointed to, it's very difficult to find any piece of literature or commentary on deliberative mini-publics and deliberative democracy that doesn't mention the Irish abortion case. And there is a sense that this is an exciting story of reform, and it's exciting for people who are interested in citizen-led constitutional change. Here we have a country with a constitution very much infused by Catholic values that undertakes a citizens' assembly looking at a topic of abortion and then votes by an overwhelming majority to liberalise the law. So on its face, it looks like a really exciting, impactful example. But there's actually very little in the way of empirical research showing how deliberative mini-publics actually impact constitutional and legislative change. And it can often be difficult to identify the cause of a particular change. But the Irish case is interesting because from looking at it closely, this is one where we can show a tangible impact of a deliberative mini-public. The reform of Ireland's law on abortion. So to tell the story of the reform of the law, we go back to the early 1980s, and at this point, Ireland became the first country in the world to vote by referendum to insert a right to life of the unborn into the Constitution. Here I've included the text of Article 43.3, commonly known as the Eighth Amendment of the Constitution, and the provision that was inserted states, the state acknowledges the right to life of the unborn. This is the first time that a right to life had been explicitly recognised in the constitutional text. And that right to life is stated to be equal to the life of the mother. Now, following the insertion of this provision into the Irish Constitution, no legislation was enacted or guidance given as to when, if ever, abortion might be permitted. But the provision was interpreted by the Irish Supreme Court in the X case in the early 90s as meaning that abortion would only be permissible under Irish law in the case of a real and substantive risk to the life of the pregnant woman. So, as you can imagine, this all but operated as a ban on abortion. Only in the most extreme circumstances of a risk to life would abortion be lawful under Irish law. And in these circumstances, perhaps acting as something of a release valve on pressure for reform, many women travelled to the UK to access abortion services. As the years went on, there was a plethora of litigation, further constitutional referendums, political inertia, and the topic became quite divisive and polarising in Ireland. And much of the dialogue, the public discourse, focused on these hard cases. So, the lack of abortion access where the pregnancy is posing a risk to the pregnant woman's life, where the pregnancy has arisen from rape or incest, or where a diagnosis has been made of a fetal abnormality. So these were the kinds of issues that were dominating the public discourse. And there were a number of tragic cases that arose over the years that really shone a spotlight on the impact of this constitutional provision. One event that took place in particular that really solidified the demand for change was the death of a pregnant woman, Savita Halappanavar, in 2012. And in response to her death in 2013, legislation was finally enacted, but it essentially just legislated in terms that the Supreme Court had interpreted the law. So there was still this very high bar to reach. It became clear that momentum had built for change. And the Irish government took a very unprecedented, unusual step. It established a citizens' assembly to consider the topic of abortion. Now, since 2012, Ireland had started experimenting with these methods of involving citizens in constitutional change. 2012 saw the introduction of the Convention on the Constitution, but the 2016 Citizens' Assembly was the first such assembly composed entirely of ordinary citizens. It was established by way of a resolution of the Houses of Parliament. It was described as an exercise in deliberative democracy that was seeking to centre the citizen in making important policy decisions. And it consisted of 99 ordinary citizens that were intended to be broadly representative of Irish society. It was chaired by the retired Supreme Court Justice Mary Lafoy. She was supported by a secretariat, which was staffed from the Department of the Taoiseach, the Prime Minister's office. And she also had assistance from an expert advisory group, and this group consisted of legal, medical, ethics, and deliberative democracy experts. The format of the process was that the citizens first underwent a learning phase about how the law was operating, and they had expert presentations. They also heard testimony from women who had personal experience of the law. They heard from different advocacy groups that had different views on how the law should be reformed. They had the opportunity to sit in round table and undergo deliberations with each other, supported by facilitators. And there was a big emphasis on transparency. Other than the closed sessions for citizen deliberation, the proceedings were all live streamed on the Assembly's YouTube, and the materials that the citizens were presented with were all published on the Citizens' Assembly's website. The Citizens' Assembly met over 5 weekends over 2016 and 2017. They received thousands of public submissions, and they ultimately made some wide-ranging recommendations. In its report published in June of 2017, the Citizens' Assembly, perhaps unsurprisingly given the way the public mood was going, they recommended taking out the Eighth Amendment, this Article 43.3, replacing it with a new constitutional provision that would empower the Parliament to legislate for abortion. But they went a step further than that. They developed a new framework for how abortion should be regulated in the event of a successful referendum to remove the Eighth Amendment. And the very surprising recommendation that came out of this process was that there should be an unrestricted right of access to abortion within a certain gestational limit of 12 weeks. And you might recall earlier, I had talked about how much of the debate had been on these hard cases. How can we ensure abortion access for women that have a fetal abnormality, women that are pregnant as a result of being raped, and so forth? This was the first time that the possibility of an unrestricted right of access to abortion had been mooted in Ireland. The recommendations of the Citizens' Assembly were passed to a cross-party parliamentary committee, the Joint Committee on the Eighth Amendment of the Constitution. This committee had representatives from all political parties and independent members also. And it really endorsed the spirit of the Citizens' Assembly's recommendations. It recommended simply repealing the Eighth Amendment, not replacing it with anything. So its constitutional recommendation did differ slightly, but it was to the same end. And it broadly endorsed the Citizens' Assembly's recommendations for legislative reform. In particular, it endorsed the recommendation to permit termination of pregnancy without restriction within 12 weeks. Following on from that, the matter was returned to government to consider how to proceed. The referendum, as we know, was held in May of 2018. Government decided to go with the Citizens' Assembly approach of replacing the Eighth Amendment with a new constitutional provision, probably on the advice of the Attorney General rather than, any sense of obligation to follow the Citizens' Assembly recommendation. But in any event, the new constitutional provision paved the way for a new statutory framework on abortion in Ireland. And the 2018 bill included this 12-week recommendation. So, how did the Citizens' Assembly impact the reform? There were some important features of the Citizens' Assembly process that when we drill into, we can see really had an impact. I had the opportunity when I was studying this reform to interview some of the people that were intimately involved with setting up the Citizens' Assembly, including the chair. And really the sense that I got is this was a first for Ireland. It was the first Citizens' Assembly composed of ordinary citizens. And, it was really coming at a time where many different forums over the years had considered abortion, and many of them had ended up in a deadlock. So something new, something fresh had to be tried in this context. And an interesting approach was taken to the learning phase. It was decided that the first step in this process needs to be to equip the citizens with the knowledge that they need of how the law is working to enable them to be able to make meaningful recommendations. And the way that abortion had been debated in Ireland over the years had traditionally been in this very divisive pro-life, pro-choice, pro-abortion, anti-abortion way. And the decision was made at the outset of the process to take a neutral approach to educating the citizens. Now, we could have a debate, and some feminist scholars have had a debate about whether it's possible to have, a neutral education phase on something like abortion. But that was the approach that was taken. Experts were invited to present to the Assembly, not on either side of the debate, but rather to give them the factual information on the constitutional provision and the law as it stood. And one particular expert, Tom O'Malley, who is an Irish legal scholar, presented to the Citizens' Assembly on the topic of the possibility of introducing access to abortion for pregnancies as a result of rape. And one of the things that really came through in that expert presentation was the difficulty of legislating for reasons-based abortion, the difficulty of establishing a procedure whereby somebody could establish that they had been raped within time to be able to access abortion services. So that was one of the expert presentations that really seemed to have resonated with the citizens. A second feature of the process was the participant input. This was not a process in which citizens were just expected to be passive recipients of information. In fact, the citizens had a great amount of autonomy and a great amount of say in the experts that they heard from and how they formed their deliberations. In particular, at the beginning of the process, it wasn't even on the agenda to include the perspectives of people that had actually had a direct experience of the Eighth Amendment. It was actually citizen feedback where the citizens said, we actually want to hear from women that travelled to access abortion, women that didn't travel. We want to hear their perspectives. So that was brought into the process in response to that citizen feedback. Another area where the citizens had a great deal of autonomy was in the ballots. So sometimes deliberative processes are seen as a process that is designed to achieve a consensus, and that's not the case. Deliberation is about acknowledging that there can be legitimately differing views on a particular topic. So the expert advisory group assisted the citizens by drafting ballots for the citizens to vote on their recommendations. But the citizens had the opportunity to parse those ballots, to study them, to make sure that they accurately reflected, not just, to make sure that all of the options that they wanted to see were on the ballot so that everybody felt like the perspective that they wanted to bring through was there and that they had an opportunity to vote. So the whole process around creating the ballots really took up a great deal of time throughout the process. Another important feature was the design. So let's zoom out from the Citizens' Assembly and look at the manner in which it was connected to the political process. The Citizens' Assembly recommendations, as I've said earlier, were passed to the Joint Oireachtas Committee on the Eighth Amendment. And this is an example of what in the literature has been described as designed coupling. This idea that deliberation isn't just about citizens sitting in a room doing a really great job, but there are different methods of plugging those citizen deliberations into the broader political process. And the interesting thing about the parliamentary committee that was established to look at this was that there were members of the committee coming in that had very definite views at the outset. Some of them declared themselves to be very much in favour of reform. You know, I've always been against the Eighth Amendment and I've always been in favour of taking it out of the Constitution. There were others that were very much in favour of the Eighth Amendment. They felt that this had saved countless lives in Ireland and that it should very much stay in the Constitution. And there were other members of the committee who said, I have an open mind. I'm willing to come in here and learn. But the important way that the Citizens' Assembly had an impact on this process was that regardless of the parliamentarians' personal views on abortion, they ended up debating the matter in the parameters as set by the Citizens' Assembly. They didn't sit down and say, let's sit down and have a blue sky discussion about this. They didn't sit down and say, let's focus specifically on how to legislate for abortion, you know, in the case of rape or fatal fetal abnormality. They took the Citizens' Assembly's recommendations as the starting point, and in particular, the 12-week proposal, the proposal that abortion should be available without restriction within 12 weeks. The committee took that as the reform at stake. So whether they agreed with it or didn't agree with it, that was the kind of the four corners within which they were debating the matter. And having had the opportunity to speak to some of the members of the committee and having, you know, studied all of the committee deliberations, many of the members of the committee pointed to the really valuable role of the Citizens' Assembly. This was the first time that a body of information had been gathered that included, you know, neutral, practical, legal information, perspectives of people that had been affected by the law. It had all been gathered and it had all been deliberated on by a representative sample of ordinary citizens. And having gone through this very thoughtful, reasons-based process, they had come out with these recommendations. And this was pointed to by parliamentarians as something that was of great value in trying to take a fresh approach to the subject of abortion that had been so divisive. When the matter came to Parliament to decide to have a referendum, the question to be put to the people on referendum was ostensibly whether to take out the Eighth Amendment. But the government made an important decision in advance of the referendum, and that was to publish a heads of bill to say, I think the government decided that, you know, trust was going to be really important in this referendum. And so they said, here's what we will here's what we will legislate for in the event that the referendum passes. So the government said, if the people vote yes to the referendum, we will introduce a new legal regime to regulate abortion, and this is what it will contain. And it was largely built around the framework that had been created by the Citizens' Assembly and then in turn endorsed by the Parliamentary Committee. The new statutory scheme included the 12-week proposal. It also included some of the other recommendations that the Citizens' Assembly had made. It had an important difference. It included a 3-day waiting period. So the heads of bill that the government published stated that they would introduce a regime whereby abortion would be available without restriction within the first 12 weeks, but there would be this waiting period. And this 3-day waiting period between the date when the abortion was requested and when it could be carried out, this was not something that had been recommended by the Citizens' Assembly or by the Parliamentary Committee. And so after the referendum, when the legislation came to be passed, it included most of these core recommendations. And there was a great deal of debate about this particular 3-day waiting period. And from my own, you know, examination of the context around it, it seemed it was really included to allay some of the fears of the more reluctant members of Cabinet that wanted there to be, you know, some barrier within the unrestricted right of access. So it's really showing a little bit of context around how the government approached this question of reform. So Let's look at how the Citizens' Assembly actually had an impact. What can we draw from this case study that might be applicable beyond the Irish case in other countries, other jurisdictions, other topics? Well, I think it's important to make a distinction between the constitutional versus the legislative impact of this Citizens' Assembly. In some of the international commentary about the Irish Citizens' Assembly, it seems to be, a rather simplistic, a straight line. There was a Citizens' Assembly on abortion, and then that led to being public consensus on the need to change the law, and then we had this referendum with this resounding outcome. And I think actually the Citizens' Assembly had a big impact, but not in creating a constitutional consensus that had not been there already. That consensus had been building over time, and there are all sorts of, contextual factors that built into that consensus. But actually, what the Assembly did was it translated that consensus into a specific legal framework that could be taken by elected representatives as the reform at stake. So this, to me, indicates deliberative mini-publics as having potential not as tools of consensus creation, but rather as tools of consensus clarification, clarifying what that consensus for change actually looked like from a concrete perspective. This is also a powerful example of a deliberative mini-public as a legislative agenda setter. As I mentioned, most of the talk, most of the opinion polls, most of the public discourse had been on the hard cases prior to the Citizens' Assembly. Once the Assembly made its 12-week recommendation, that recommendation really became the centre of the discourse. This was the reform at stake. And I think it was this crucial connection between the Assembly and the Parliamentary Committee that allowed the Assembly to have that agenda-setting role. Of course, there were other influences, the Attorney General, the government's own legal advice, the 3-day waiting period, which seems to have come out of, some of the usual political horse trading. But we can clearly trace the Citizens' Assembly's recommendations from their inception at the Assembly through the entire political process to enactment into law. And this really brings home the importance of institutional design in creating a process whereby assemblies composed of ordinary citizens can really have an impact. And I've identified the Parliamentary Committee as being key to that impact. But I would note a sound of caution there for deliberative democracy purists, because the committee did have an important filtering and legitimacy creating role in respect of the Assembly's recommendations. The Citizens' Assembly actually made very wide-ranging recommendations beyond the 12-week recommendation. It made various recommendations for abortion beyond 12 weeks, for example, for rape and for socioeconomic circumstances. And those were not taken up by the committee. The committee took the view that the unrestricted right of access within 12 weeks would be sufficient to deal with the majority of abortions that were already taking place. So the recommendations that the Assembly made that were not taken up by the committee did not go any further into the process, and they certainly were not revisited by government when the time came to legislate. So all of this shows us the powerful impact that a Citizens' Assembly can have in a constitutional and legislative change. But it also alerts us to some of the legitimacy issues around citizens' assemblies. There are those that, take the view that, these are unelected citizens. Why should they have, an influential role in constitutional change or in legal change? But there are also those of us, who do take a positive view of the potential of citizen deliberation, but would question, for example, is it possible to actually gather a truly representative sample of ordinary citizens? And perhaps the most representative citizens among us are those of us who are busy, who are working, who have family and caring and community responsibilities, and don't have time to spend 5 weekends deliberating on a particular constitutional issue. So similar to some of the problems about jury selection, is it truly possible to get a representative sample of citizens, or do we only get a sample of citizens that have, a higher than average interest in political matters and therefore may not necessarily be representative of the rest of the community? So those are just some of the issues that go to creating these processes. And now, as I come to the last couple of minutes, I want to consider what the Irish experience can tell us more broadly. So what potential is there for deliberative mini-publics in other countries, in Canada? So interestingly, the Irish experience was inspired by Canada. One of the first modern experiments with incorporating deliberative mini-publics into public decision-making began with citizens' assemblies in 2004 and 2006 in BC and Ontario, where citizens' assemblies considered the topic of electoral reform. But since then, the momentum around citizens' assemblies in Canada has waned, whereas in countries like Ireland and in other countries across Europe and across the world, it has really taken off. So I would argue that there is a case for revisiting the Irish experience, and the experience of other countries really do indicate, the power of these mechanisms. The electoral reform context in Canada is often pointed to as, an unsuccessful instance of citizen deliberation because it didn't result in electoral reform. The recommendations made never came to fruition. But actually, I think they can be looked at a different way. I think they can be looked at as a very successful example of how citizens were able to get to grips with a very complex topic, different electoral systems, and produce concrete recommendations, albeit that they weren't actually translated into reform when it came to referendum. We are living in an age now in Canada and in many other countries where public confidence in institutions is low. This is corrosive to our democracy, and I think there's a case to be made for enhanced mechanisms of involving citizens more meaningfully in shaping public decisions. The Irish case and even the Canadian electoral reform case show that citizens are capable not only of value deliberation, so deliberating on broad constitutional values, but they are also very capable of applied deliberation, translating those broad values into, concrete policy recommendations. And finally, I think that there are many areas of law and policy in Canada now that are in need of reform and that would be suitable for citizen deliberation. And we can talk about what those might be a little more in the Q&A. But one example that I picked out here is the law on MAID, medical assistance in dying. And this is a topic that has some features in common with the Irish abortion case. It's something that people have very deep convictions on both sides of the debate. It's something that other forums have looked at in the past. There have been expert advisory groups, legal experts, medical experts, parliamentarians that have looked at this. But what has been missing from the debate, I think, has been the voices of ordinary citizens, and particularly with the paused expansion of MAID earlier this year, it really demonstrated how this has become a logjam, and the potential, for citizens to bring a fresh perspective to this potentially polarizing topic in much the same way that citizens managed to do in the Irish abortion context. So I think I'm just about on time. I think I'll wrap up there, and I'll be delighted to take any comments and questions that you might have.